A lot of businesses are familiar with the three big types of intellectual property: trademark, copyright, and patent. What many businesses are not aware of is which one of these assets, which one of these rights is correct for them. Trademarks are meant primarily for the devices that a business uses to draw its customers to it and to identify itself in the marketplace. Simply put, it's the name of the business. It's the design, the logos, the icons that they use. It's the taglines. It could be trade dress, such as the way a restaurant is laid out or a store is configured on the outside. All these items say to the world, hey, you're now walking into my store, not one of my competitors. That's the job of trademark. Copyright is primarily meant for the arts. When you think of copyright, you should be thinking of written words, music, art. These are primarily the area of copyright. However, software code can also fall in this, and many other business assets, such as your website itself and all the content that's on your website, could be protected most readily by copyright. Patent is primarily meant for protecting inventions. When you think of very simple things such as the telephone or the airplane, the items that help these products work are protected by patent. So if you have an invention or a process that you think is unique, patent is probably the right tool for you to use. Once you determine that a trademark application is the right step for you, you need to prepare ahead of time to make sure that you're going in the right direction. First, you need to start with a search. There's really no way to adequately prepare an application to get a trademark registered without understanding exactly what it is you're aiming for. I like to think of it as actually looking at a golf hole before you swing. You might have a great swing, but if you don't know what you're aiming for, you're not going to hit it. Once you determine that a trademark application is the correct thing for you to do, and you understand what brand you're going to be protecting and what goods and services you're selling, you need to gather some other information. Primarily, you need to get specimens of use, which is the things that you can show to the trademark office to prove that you're currently selling your brand in commerce. You also need to get information about the applicant that's going to be filing the application. Is this going to be a business? If so, where is the business organized? What type of entity is it? What state is it organized in? Where is its domicile? If it's an individual, you need to understand the citizenship and also the address for the company, also the address for the individual that's going to be seeking the protection. The United States Patent and Trademark Office has a very simple application system for you to use. They call it the Trademark Electronic Application System, or TEAS. TEAS is going through a revamp at the beginning of 2025, and actually is going to be much different in a few weeks than it is today as I'm recording this. I've looked at the new system, and there's not a lot of difficulty in it, but you need to get a lot of information gathered before you're filling out the application. Also, don't be fooled by how simple it looks to fill out the application. While it seems easy to answer the questions that they have presented on the screen, the answers are going to lead you towards different types of rights, and filling them out in a way that's advantageous for you is a very difficult thing often. Once you file a trademark application, the application itself goes into a long waiting line. Currently, there's about a 6 to 8 month wait before the United States Patent and Trademark Office assigns an examining attorney to look at your application. At that time, the attorney is going to look at a lot of items I've already looked at during the search, such as whether or not the brand is so distinctive enough to gain trademark protection, and also whether or not there's a likelihood of confusion with the brand you're seeking to protect versus what's already in the database. There's a lot of other nuance examining attorneys looking at as well that I can help guide you through to make the examination process much easier. For example, most people don't understand that you cannot put a PO box in the application. A lot of businesses have a UPS store or similar store that they use as an address. The United States Patent and Trademark Office will not accept this, and you will receive an office action for this. Another thing that confuses a lot of people is what exactly is an appropriate specimen of use. Very simply put, a specimen of use is something that you're showing to demonstrate that you're currently selling goods or services under your brand. While it seems like it should be simple, there's a lot of nuanced rules that the Trademark Office has about what they will and won't accept and how it should be formatted and framed so the examining attorney gets all the information they need. Getting that into the application on the front end will reduce a lot of frustration along the way. Also, you should note that receiving an office action is incredibly common. Whether I file an application, that is a professional that knows the system very well, or someone files an application on their own, approximately 80 to 85% of all applications receive an office action. I don't review an office action as a bad thing. I review it very much like having to stop at a gas station on the way to the beach. It's not what you want, but it's part of the process. What's important, though, is that you know what the office action will include and what your plan of attack is to overcome and respond to the office action. You have 3 months to respond. What are you going to do and how are you going to do it? And did you get the office action, that is the comments from the trademark office, that you expected? And do you know what you're going to do to respond to it? To get a trademark registered, you obviously need to do more than simply file an application. I've already mentioned that there's an examination process by the government. Behind that, there's also an examination process by third parties. Once the government approves your application, it goes into a status known as publication. That's a period of time that any third party that wants to can oppose your application. I mentioned that the government issues refusals to approximately 85% of applications filed. This number is vastly different in the publication period. Approximately 2% of applications that are published get opposed by a third party. And my information shows that about 90% of those people expected the opposition. Many times it was part of the fight that was already going on. So you shouldn't necessarily expect to receive an opposition from a third party, but if you do, don't ignore it. You will not get a registration unless you do resolve those issues with that third party. Finally, if you filed your application based on intent to use, there's one additional step for you. Instead of receiving a registration after publication, you'll receive what's known as a notice of allowance. That's a 6-month window of time that you can file a statement of use to receive your registration and complete your registration process. Receiving your registration is not the end of the process. First of all, and most importantly, you need to continue to use your brand in commerce. In the United States, this is the only way that you can protect your rights. Anyone can move to cancel your registration if you've stopped using your brand for a period of 3 years or made some sort of declaration that you're no longer going to be using that brand. In addition to using the brand, there are certain filing periods that the government has for you to be able to maintain your registration. This starts between the 5th and 6th anniversaries of registration. You need to file what's known as a declaration of use so that the government can know that you're continuing to use the brand. The reason for this is the government wants to make sure that brands are no longer being used or removed from the registry system, as they are clogging it up and preventing other people from getting registrations for similar brands. After that 5th and 6th year maintenance period filing, you have an additional renewal filing between the 9th and 10th anniversaries and every 10 years thereafter. So every brand, every 10 years, needs to check in with the government and let the government know that they're continuing to use the brand. Receiving trademark rights and getting a trademark registration is not a straightforward process. A lot of it looks simple at the beginning until you dive in a little bit and understand that there's a lot of nuance. I help companies every day go through that nuance. My job is to help companies achieve trademark rights and registrations and make sure that they get them as efficiently and fastly and inexpensively as possible. If you want to reach out to me, I'd love to take your call. You can reach me at Initiating Protection at area code 678-965-3268.